26 people say a machine decided to end their careers, and that it waited until they were on medical leave to do it. 3 days later, a federal judge handed down his first ruling. This is AI versus the law. On July 14th, 26 current and former Meta employees sued the company in federal court in California. Their allegation is specific. When Meta cut roughly 8,000 jobs this year, about a tenth of its entire workforce, it leaned on an AI system to help decide who went. And the way that system scored people, the lawsuit says, was rigged against anyone who had stepped away from work to survive something. Here's the exact claim. Read that again. By design. The plaintiffs say the model rewarded output and activity, and if you were on parental leave, on medical leave, or living with a disability that slowed you down, you simply could not score high enough. Nobody had to tell the AI to target you. The metric did it automatically, and it gets more specific. The workers allege Meta used AI to monitor employees' keystrokes and computer activity to score, rank, and select who landed on the cut list. Not a manager reading your reviews, a system watching your keyboard. Why does this end up in court and not just in HR? Because leave and disability protection is some of the oldest, clearest law in the American workplace, the Family and Medical Leave Act, the Americans with Disabilities Act, the Pregnancy Discrimination Act, Title VII of the Civil Rights Act. None of them care whether the decision came from a vice president or a model, and the workers are reaching for the most dangerous theory in that toolkit. Disparate impact. They don't have to prove Meta wanted to punish leave takers. They only have to show the neutral-looking system landed on a protected group and then let discovery ask why. Then, on July 17th, the case had its first real test, and this is where it gets complicated. The workers had asked for an emergency order to stop their layoffs immediately. Senior U.S. District Judge William Orrick said no. His reasoning was narrow. Getting laid off, he wrote, is serious, but it can be remedied through damages, back pay, or other comparable relief. In plain terms, if they win later, money can fix it, so there is no emergency today. But Orrick did not throw the case out, and he carved out one exception that matters enormously. 4 of the plaintiffs are in this country on work visas. Lose the job, lose the visa. The judge said their risk of being forced out of the United States within 60 days was more than speculation. So Meta now has to file a sworn declaration about those 4 workers by July 23rd, and a full hearing is set for August 24th. Now Meta's side, because this is a fight, not a verdict. Meta's lawyer, Aaron Connell, told the court there is no evidence that AI was used to make decisions in this reduction in force. It's truly based on speculation and conjecture, and the company's public line is the same, that workforce decisions were made by people, not AI. So the entire case now hangs on one question. Was there an algorithm in that room, or wasn't there? And the only place to answer it is the evidence. Here's the twist. Most of the coverage is missing. These workers' claims are headed to private arbitration, not a public jury. That's the quiet part. Meta, like most large employers, has agreements that push disputes out of open court and behind closed doors, which means the model's logs, the scoring code, the keystroke data, all of it could get examined somewhere the public never sees it. The workers' emergency motion was, in part, an attempt to keep this fight in the daylight. They mostly lost that. Those 4 visa holders are the one crack of light still open. Our prediction on the record. Watch July 23rd. Meta's declaration about the visa workers is the first time the company has to put sworn specifics on paper about how these layoffs were actually decided. Every word will be lawyered, but it is the first thread. Then watch August 24th. If Judge Orrick lets the visa holders' claims move forward, Meta faces the choice no employer wants. Open the model to scrutiny or settle before anyone can look. My call. This never reaches a public ruling on the AI itself. It settles, or it arbitrates in the dark, unless those 4 workers pry it open. Clip this. What's next? The July 23rd filing, the August hearing, and a question now hanging over every company running so-called workforce analytics. If your model can rank people, can it be sued for how? 26 people just made that question real. New case file every week. Subscribe, the verdicts are coming.